It is not often that the day announces itself before the sun does, but this one did. At 5:47 inches the morning, when Manhattan is still stretching awake and the street sweepers are louder than the traffic, a convoy of 6 black SUVs turned onto Fifth Avenue and came to a stop outside Trump Tower. Not casually, not quietly, deliberately. Doors opened almost in unison. Approximately 30 FBI agents stepped out, not in a rush, not in chaos, but with the kind of choreography that signals preparation. They carried boxes, evidence bags, search equipment, and at exactly 6 a.m., the lead agent presented a federal search warrant to building security and made something very clear. They had authorization, they needed immediate access, and no one was to interfere. That moment, that piece of paper, signed by a federal magistrate, is where this story actually begins. Because search warrants do not materialize out of thin air. They are the product of weeks, sometimes months, of quiet work. Affidavits drafted, evidence compiled, legal standards met, judges persuaded. And by 6:17 a.m., those agents were inside the executive offices of the Trump Organization on the 26th floor, beginning what would become a 9.5-hour search that transformed a Manhattan morning into a national legal drama. To understand what unfolded inside that building, you have to understand what it takes to get there. On January 12th, federal prosecutors in the Southern District of New York, that office with a long institutional memory and a reputation for methodical prosecutions, filed a sealed motion before Magistrate Judge Sarah Netburn. The motion requested authorization to search Trump Tower. Not a subpoena, not a request for voluntary production, a search. The difference matters. A subpoena invites compliance. A search warrant compels it. According to sources familiar with the filing, prosecutors alleged probable cause to believe that evidence of federal crimes existed within Trump's business offices. The statutes cited were not vague or symbolic. Tax fraud, bank fraud, obstruction of justice. Crimes that hinge not on rhetoric, but on numbers, on documents, on what was written down and submitted to institutions that rely on accuracy. The supporting affidavits reportedly included input from IRS, investigators, and FBI agents detailing financial transactions, communications, and witness testimony pointing to records stored at that specific location. On January 15th, Judge Netburn reviewed that material. A magistrate judge does not approve a search of this magnitude lightly, particularly not at the headquarters of a former president's business empire. The standard is probable cause, a reasonable belief that a crime has been committed and that evidence of that crime is located at the place to be searched. She signed the warrant. And in that signature, the trajectory of this story was set. By the time the agents entered the building, they were operating within defined parameters. The warrant authorized the search of Trump's executive office, conference rooms on the 26th floor, and file storage areas. It specified categories of documents: financial records from 2015 through 2023, tax returns and supporting schedules, communications with accountants regarding asset valuations, loan applications and supporting materials, and records related to specific properties, including Trump Tower itself, 40 Wall Street, and the Trump International Hotel. It also authorized the seizure of electronic devices that might contain relevant information. And then, at 6:34 a.m., while agents were inside, Donald Trump responded. Posting from Mar-a-Lago, he characterized the search as illegal, as prosecutorial misconduct, as election interference. He alleged without evidence that agents were planting material. The language was familiar: witch hunt, radical prosecutors, third world tactics, but the legal reality remained unchanged. A federal judge had authorized the search. The agents were not freelancing. They were executing a court order. At 7:15 a.m., Trump's attorney, Alina Habba, arrived at the building. She was permitted to observe, but not interfere. She reviewed the warrant and objected that it was overly broad. That objection may become relevant later in court. But in that moment, the search continued. Agents moved methodically, photographing locations, cataloging materials, boxing documents. By 8:47 a.m., witnesses outside reported seeing boxes marked as evidence being carried out and loaded into vehicles. By 9 a.m., at least 15 boxes had reportedly been removed. And at 10:23 a.m., the U.S. Attorney's Office for the Southern District of New York issued a statement confirming that agents were executing a court-authorized search warrant at a Manhattan location as part of an ongoing investigation. No details, no commentary, just confirmation. Former U.S. Attorney Preet Bharara, who once led that same office, appeared on cable news and underscored what many legal observers already understood. Judges do not sign warrants for high-profile targets without substantial evidence. The issuance of the warrant itself signals that prosecutors presented something persuasive. As the morning turned to afternoon, the search expanded. At 12:15 p.m., agents reportedly entered basement file storage rooms containing decades of business records, hundreds of boxes, some undigitized. Agents photographed, reviewed labels, selected specific boxes. By 1 p.m., the number removed had reportedly climbed to at least 30. Trump posted again at 1:47 p.m., accusing prosecutors of conducting a fishing expedition. But search warrants, by design, are bounded. They describe the places to be searched and the items to be seized. Agents are required to inventory what they take and provide that list to defense counsel. That inventory will matter enormously. It will reveal not speculation, not rhetoric, but precisely what federal investigators now possess. There are indicators that legal analysts watch in moments like this. The volume of materials seized, whether electronic devices were taken, whether personal office documents were included, the duration of the search, whether emergency motions are filed. By 2:34 p.m., Trump's attorney filed a letter demanding the search be halted, arguing constitutional overbreadth and irreparable harm. The court did not intervene. The search continued. At approximately 3:30 p.m., after 9.5 hours, the convoy departed. Estimates suggest between 40 and 50 boxes of documents were seized, along with multiple electronic devices. At 4 p.m., prosecutors confirmed the search had concluded and that an inventory would be provided as required by law. At 4:47 p.m., Trump addressed the public via video, again denouncing the search as an outrage, insisting he had done nothing wrong, promising to fight in court. He took no questions. So what happens now? The next phase is quieter, but potentially more consequential. Prosecutors will review the seized materials. They will compare financial statements submitted to banks with valuations reported to tax authorities. They will analyze communications with accountants and lenders. Financial crimes cases often hinge on discrepancies on numbers that cannot simultaneously be true. If documents reveal inflated valuations used to secure loans and deflated valuations used to reduce tax liabilities, that pattern can support fraud charges. If internal communications demonstrate knowledge of those discrepancies, intent becomes easier to establish. And unlike cases rooted in executive authority or political speech, financial cases revolve around paper trails, bank records, tax filings, spreadsheets, emails. There are 3 broad paths forward. Charges could follow if the evidence supports them. The investigation could stall if it does not. Or defense attorneys could successfully challenge aspects of the warrant and seek suppression of certain materials. But suppression requires showing that the warrant was defective or improperly executed. That is a high bar. What distinguishes this search from the 2022 search of Mar-a-Lago is its focus. That earlier episode centered on classified documents and national security. This one centers on business records and potential financial crimes. Different statutes. Different evidentiary burdens, different prosecutorial strategies. By the end of the day, what was certain was this. Federal agents executed a court-authorized search warrant at Trump Tower. They searched executive offices, conference rooms, and storage areas. They seized dozens of boxes and electronic devices. The search lasted 9.5 hours. It was not stopped by the court. An inventory will follow. And prosecutors now possess a substantial body of material they believe may contain evidence of federal crime. In investigations like this, the most dramatic moment is often not the flashing lights or the convoy at dawn. It is the quiet analysis that follows. The careful review, the decision memo, the weighing of evidence against statutory elements. Somewhere, in a secure facility, agents and prosecutors are beginning that process now. This is not the end of the story. It is the beginning of a new phase. The raid is over. The documents are in federal custody. And what those 40 to 50 boxes contain will determine whether this morning on Fifth Avenue becomes a historical footnote or the opening chapter of a federal indictment. And here is where the story shifts from spectacle to consequence. Because once the SUVs have disappeared down Fifth Avenue and the doors of Trump Tower close behind the last departing agent, the center of gravity moves somewhere else entirely. It moves into fluorescent-lit rooms inside secure federal facilities. It moves onto long conference tables where bankers' boxes are opened one by one. It moves into digital forensics labs where hard drives are imaged, phones are cloned, and metadata is extracted with surgical precision. That is where the real weight of a day like this settles. Prosecutors from the Southern District of New York now face a task that is less visible but far more determinative than the search itself. They must answer a deceptively simple question. Do the documents seized prove, beyond a reasonable doubt, that federal crimes were committed? Not do they suggest irregularities, not do they raise suspicions, but do they satisfy the elements of tax fraud, bank fraud, or obstruction under federal law? Financial crime cases turn on comparison. What was represented to banks in loan applications? What was reported to tax authorities? What internal valuations were circulated among executives? And perhaps most critically, what did decision makers know about discrepancies? And when did they know it? If, for example, a property was valued at one figure to secure favorable lending terms and at a dramatically lower figure to reduce tax liability, prosecutors will examine whether those divergent valuations were supported by legitimate methodology or whether they were knowingly false. The inclusion of electronic devices in the seizure matters enormously. Paper documents tell part of a story. Emails, text messages, draft spreadsheets, and internal memos tell the rest. Intent, the mental state required for fraud, is rarely confessed outright. It is inferred from patterns, from warnings ignored, from conversations in which someone raises a red flag and is overruled. Digital communications often supply that connective tissue. Trump's legal team, led publicly by Alina Habba, will almost certainly scrutinize the inventory once it is provided. They may file motions arguing that agents exceeded the scope of the warrant. They may seek the appointment of a special master to review materials for privilege. They may argue that certain documents fall outside the categories authorized by Magistrate Judge Sarah Netburn. These are not symbolic gestures. If a court were to suppress key evidence, the trajectory of the case could change dramatically. But suppression is not easily won. Courts give deference to warrants that are specific and supported by detailed affidavits, and by all accounts, this warrant was not improvised. It was built on weeks of investigative groundwork. IRS investigators, FBI financial analysts, witness interviews, transactional records. The search itself lasted 9.5 hours, long enough to suggest agents were working from a carefully prepared roadmap rather than casting a wide net. There is also the political dimension, which cannot be ignored but must be separated from the legal one. Trump has framed the search as election interference, as prosecutorial overreach, as a witch hunt. That narrative resonates with his supporters. It fuels fundraising, it galvanizes a base, but in a courtroom, rhetoric carries no evidentiary weight. Judges evaluate affidavits, not press conferences. Juries weigh documents, not social media posts. The Southern District of New York has a history of pursuing complex financial cases. Its prosecutors are accustomed to unraveling layered corporate structures and intricate accounting practices. They understand that fraud cases are won not with dramatic testimony, but with meticulous documentation. A loan application here, a tax schedule there, an internal email acknowledging that a number looks aggressive. Piece by piece, a mosaic is constructed, and that is what may now be happening behind closed doors. Agents cataloging each seized item, prosecutors cross-referencing documents with prior testimony, forensic accountants reconstructing timelines. If discrepancies align with statutory definitions of fraud, material misrepresentations made knowingly to obtain money or favorable terms, then charging decisions will follow. There are practical considerations as well. Indicting a former president carries extraordinary implications. Prosecutors must be confident not only that evidence exists, but that it is admissible, coherent, and compelling. They must anticipate defenses, that valuations were subjective, that accountants were relied upon, that any inconsistencies were unintentional. They must prepare to rebut claims of selective prosecution. Meanwhile, Trump's attorneys may pursue an aggressive counter-strategy. They could request discovery of the underlying affidavits supporting the warrant. They could challenge the breadth of categories such as financial records or communications with accountants. They could argue that certain materials are protected by attorney-client privilege. If a special master is appointed, that review process could slow the investigation's momentum. But time cuts both ways. The longer prosecutors deliberate, the more public scrutiny intensifies. The more speculation fills the vacuum. Markets react. Political campaigns adjust. Allies distance themselves or double down. And through it all, the evidentiary clock ticks forward. One of the most consequential aspects of financial crime investigations is that they often reveal patterns extending beyond a single transaction. If seized documents suggest systemic misrepresentation, repeated inflation of asset values for loans, and repeated deflation for taxes, the scope of potential charges broadens. Conspiracy statutes may come into play, false statement statutes. Each carries its own elements, its own penalties. The 9.5-hour search at Trump Tower may ultimately be remembered less for its optics than for what followed in quiet review sessions. Prosecutors will likely construct detailed charts mapping representations to banks against filings to tax authorities. They will interview witnesses anew, confronting them with documents seized that morning. They will test explanations against paper trails. And then comes the moment that defines investigations like this. The charging conference, senior prosecutors, perhaps including leadership from the U.S. Attorney's Office, gather to evaluate whether the evidence satisfies the burden required to present a case to a grand jury. They weigh strength against risk. They consider precedent. They assess whether they can prove intent beyond reasonable doubt. If they decide yes, a grand jury will be convened or reconvened. Evidence will be presented in secrecy. Witnesses will testify. Jurors will deliberate. And if an indictment issues, it will not be because of political rhetoric or public pressure, but because 12 citizens concluded that probable cause exists to believe crimes were committed. If they decide no, if evidence falls short, if intent cannot be established, if discrepancies can plausibly be explained, then the boxes seized will become part of an investigative archive. Trump will claim vindication. Prosecutors will close the file quietly. There is also the third path, the one less discussed but legally potent, partial success. Prosecutors may determine that some transactions warrant charges while others do not. They may narrow the focus. They may bring counts limited to specific years or specific properties, such as 40 Wall Street or the Trump International Hotel, if those records present the clearest discrepancies. In all of this, the inventory list becomes a document of consequence. It will detail every box, every device, every file taken. Defense attorneys will parse it line by line. Analysts will examine it for clues about prosecutorial focus. If categories emphasize communications around certain dates or properties, observers will infer investigative direction. The public narrative may oscillate between outrage and anticipation. But in federal investigations, patience is often the defining characteristic. Cases are not rushed to satisfy headlines. They are assembled to withstand cross-examination. As evening settled over Manhattan, what remained was not the spectacle of flashing lights, but the reality of federal custody. 40 to 50 boxes, multiple electronic devices, thousands, perhaps tens of thousands of pages and files. Data points awaiting interpretation. This is the inflection point. The search itself was a statement. Prosecutors believe evidence of federal crimes may exist at the headquarters of the Trump Organization. The review will determine whether that belief matures into formal charges. And so the next days and weeks will unfold largely out of public view. Motions may be filed, hearings scheduled, statements issued. But the decisive work will occur in careful analysis rooms where documents are compared, numbers reconciled, and narratives tested against facts. At 6 a.m. this morning, agents entered Trump Tower with a warrant. At 3:30 p.m., they left with boxes. Between those times, a legal threshold was crossed from investigation by request to investigation by compulsion. That shift signals seriousness. Now, the question is not whether the search happened. It did. Not whether documents were seized. They were. The question is what those documents prove. Do they reveal intentional deception? Or do they reflect aggressive but defensible accounting judgments? That determination will shape not just the future of one investigation, but potentially the political and legal landscape surrounding Donald Trump. The raid is over. The analysis has begun. And somewhere inside those boxes and on those drives lies the answer to whether this morning's convoy was the prelude to an indictment or a dramatic chapter in a case that ultimately stalls. The country now waits not for sirens, but for decisions.